petitioner's case. And because there are many petitioners, I was just saying the person most affected is the first.
My lords and my ladies, on our part, the current petition if in the reading the court, one is going to get petitioner, we'll just take 20 minutes in the conversation.
Even as we left the submission, again, that the day has zoning. So we will proceed on the basis that we will give you as much time as humanly possible to begin a day.
We agree. Hello? May I start here?
Yes.
We recollect that when we last appeared before this noble court on the 24th of February 2025, I stated of His Excellency regarding Gachagua that he was abandoning his prayer for reinstatement as Deputy President of the Republic of. To that end, His Excellency Rigathi Gachagua amended and served his re-amended August 2025, in which re-amended further re-amended petition. We abandoned the prayer of my Lord, your leadership, to reiterate that position on record. My lords, the prayers of the first to R in the same further amended petition, which, as I have said, is dated 13th of August 2025. The of those prayers with our submissions, the question of the unconstitutional impeachment. Number two, payment of the remuneration we would have otherwise, of course, all the benefits as per the law. Damages. Finally, for the period of 2.5 years that he served as the second deputy president of the Republic, it is also sufficient that Article 151 of the Constitution and your leadership to have a look at that Article 151 when you retire. Briefly, my Lord, impeachment retrospective That is the submission. Lords, Your Lordship, the petitioner, first petitioner, relies on the following documents. Amended petition dated 13th of August 2025. The verified affidavit thereto, and the annexion volumes dated 18th of October 2024. Number two, his bundle of authorities and case badges dated 7th of October, the first petitioner's written submissions dated 7th October 2025, which submissions are the ones we are highlighting. Lords, paragraph 1 to 19. My colleague is drawing my attention that we also remind of the first petitioners which you are served regularly in the day. The rejoinder is dated 27th of April 2026. Thank you. Lords, Your Lordships, paragraph 1 to 19 of our written submissions sets and I politely invite this Honorable Court when it requires to read this background in full. It matters in that background. And the first one is to emphasize the total and absolute lack of meaningful public participation. This will put attention to paragraph 5, which you will find of our written submission. National Assembly conducted a public participation exercise on the 4th and 5th October 2024. However meaningful, the exercise did not provide the public, for example, with the Deputy President's side of the story. The public was only presented with the assembly, and our submission is that if there is going to be effective public participation, it was essential for the public to be presented with what the Deputy President was proceed. But that was never done. Of Nairobi, capital city. The public participants are doing what the Constitution requires, when in fact nothing of the sort was happening. Lord, if you look at paragraph 10 and 11, and they appear from page 8 of our written submissions, paragraph 8, the Lord, you see, the respondent, the third respondent, convened a session of the Senate on 8th of which resolution that the plenary would hear and consider, and I pause here to emphasize the word plenary, because both the Constitution and the standing orders of the Senate divide impeachment proceedings into stages: committee and plenary. And if the person is fair trial in the impeachment, the Senate cannot legally, constitutionally bypass the committee. It is the committee that accords an opportunity to the person to be impeached to be fully heard, not the plenary. And we will be highlighting our understanding, our interpretation of the law. Of the Constitution, the standing order, it was not open to the Senate to bypass the committee of the Senate, where the law gives the Deputy President, the first petitioner, the opportunity before a smaller committee, evidence, be represented and be heard. And the 10 days that later the Senate imposed itself on refer not to the plain hearing before the Senate commenced a schedule on 16th of October 2024, when the Honorable Mwengi Mutuse's evidence was taken through all that, Valane friends here. Number 10, paragraph 10, on 17th of October 2024, that was on the second day of the hearing, the Senate allocated the deputy to present his case. You will see, and you will be addressed, my lords, the fact that somehow the National Assembly was allocated 3 hours. Being impeached was the Deputy President, not the National Assembly. Lord, all these and many more is evidence of clear bias on the part of the Senate, despite the Senate being presided, and I must state this, by a speaker who I personally have the highest regard for as a professional. But on the second day, and I'm looking at paragraph 10, when the Deputy President was supposed to present his case in the 2 hours that he had been allocated for urgent medical attention, Rejecting the request for adjournment, the Senate voted to impeach the Deputy President on 5 out of the 11 in RG 11, Volume 9, pages 1689 to 1725. Response by Brigadier Gachagua. And also Volume 9, pages 1752 to 1758, communication from Nigeria. Lord, the third matter I wish to very quickly draw background is the absolute failure for both the National Assembly and the Senate to address their minds. Impeachment of a person elected into office by a plurality of votes. And here my Lord permit me to draw the court's attention to the fundamental distinction between parliamentary systems. In a parliamentary system of government, members of parliament are entitled and have the right to kick the Prime Minister out of office simply resolution. No one can question the members of parliament why they had lost confidence in the Prime Minister. There are many examples of parliamentary system. England is a parliamentary system. Although in South Africa they call their CEO president, it's actually a parliamentary system because the president of South Africa is elected not by a plurality of votes, but by votes, a majority of votes. August 2010, that they wanted to give unto themselves a pure presidential system. Therefore, it is not the case under our Constitution. Members of the National Assembly can vote and Christian their resolution that there are breaches of the Constitution. When you be addressing this fully, when we have the number vote of no confidence, not violation of the Constitution. That is not what is permitted in our Constitution. And my Lord, an impeachment is an important remedy, but one of last resort. In other words, there must be no other way of dealing with the person being criticized. In the National Cohesion Act, currently headed by my friend Reverend Court, one of the charges leveled against the first deputy, the first petition, was making utterances that, strictly speaking, should have been reported. If impeachment is a last resort, why was the deputy president being rushed to impeachment on matters in respect of which he could have been taken to that National Cohesion Commission and even prosecuted, not respecting the important dictate in presidential system that impeachment is a last resort. It is one to be used where there is an injury to the people. Why is that? Because in a presidential system, it is the people themselves, both the president and the deputy president. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed to that, the will of the people should therefore not be overturned on flimsy grounds. And Lord, what I am highlighting here is what the court says in the song called Moving Gideon Kioko and another versus Nairobi City Council. So this is the judicial interpretation that is being accorded in respect of presidential system. It must, by the official proposed to be impeached, cannot wait to be corrected through the ordinary electoral cycle. There should therefore be a clear nexus between the alleged wrongs with the public trust bestowed on the governor, in this case the deputy president, upon the High to determine if the facts in support of the charges against the deputy president meet and prove the threshold in Article 181 of the Constitution, which is why we are before this honorable court. It is that petitioner has the opportunity to state his case and to point out the lack of that high standard of gross violation of the Constitution or other written law that the Constitution prescribes. My Lord, let me now, that was a few words about the introduction. Let me now go to the issues that I need to highlight. My Lord, if you go to page 11, you will see 8 issues we have drafted arising from the first petitioner's petition and our written submission that this honorable court should bring this issue. My Lord, those 8 issues are the ones we have divided amongst ourselves as council, appearing for the deputy president to be addressed by each one of us. But Lord, we will avoid as much as possible not to be repetitive, but there will be different dimensions to each of the issues that will be addressed. Now, the issues I want to address in those issues listed in paragraph 17 are one, or rather A, whether the motion at the National Assembly met the constitutional threshold under Article 145 and whether there was adequate public participation. And the second one, the Senate, its interpretation of Article 145 rushed the process and denied the Deputy President a fair hearing. And it is our submission, very critical submission, as we shall be seeking to do here, that the Deputy fair hearing, and a fair hearing is cardinal in our administration of justice from time immemorial, even prior to the 2020 Constitution. And the third one is whether the overnight clearance evidenced a predetermined process, whether that was unconstitutional. My Lord, your leadership, the motion by the National Assembly was defective and failed to meet the constitutional threshold. First, the allegations and evidence in the impeachment motion at the National Assembly, constitutional threshold of Article 145(1). And you will find that in Exhibit RG1, Volume 1, page 2 to 41, the notice of motion. Now, in Martin, Nyaga, Wambora, and 3 others, the Court of Appeal held that the facts that prove before the relevant constitutional order. My Lord, your leadership, my learned friend Dave Wanjiru here, and myself had the privilege of arguing the Wambora case. That's correct. It is a high standard in presidential systems. Not each, and you will find that in the Wambora case, our Battle of Authorities, paragraph 45, pages 45 to 46. Not each violation the drafters of the Constitution could have said violation of the Constitution or other written law. They did it. The word gross must carry the true intention of the drafters of our Constitution. This is the Court of Appeal in the Wambora case saying not every violation amounts to a gross violation. The charge must expressly state that the alleged violation is gross and give particulars of the alleged gross violation. Whatever is alleged, Governor, the law that this court will be laid down or reiterate will apply to the impeachment of the president himself. It's very weighty issue that this court is asked to confront. Whatever is alleged must be serious, substantial, and weighty. There must be a nexus between the person to be impeached and the alleged gross violation of the Constitution or any other written law against the governor, or the particulars thereof must disclose a gross violation of the Constitution or any other written law. D. The charges as framed must state with a degree of precision the article or articles, even sub-articles of the Constitution or the provisions of any other written law that have been allegedly been grossly violated. Here, my lords, in the case before this honorable court, the allegations were vague, lacking in detail, in failing to apply the threshold and standard of proof applicable to impeachment proceedings, thus violating Article 145. For example, although the court in the Robert Alive as an Attorney General case, which is reported in 2017 6090, nullified Section 132 of the Penal Code. The court nullified 5 years before the Deputy President's election to office. Ground 8 of the impeachment motion alleged that the Deputy President had violated that nullified law warrant by impeaching the Deputy President on the basis of a section that had been nullified by this court. What he didn't know was the National Assembly sending to the public who had elected the Deputy President with over 71 million votes. This is demonstrative of the casualness of the National Assembly in performing a very important duty imposed by the Constitution of India. Another 62 allied case, pages 62 to 63. And although Article 145 1B only applies where there are serious reasons for believing that the Deputy President has committed a crime, in ground 8, the National Assembly resolved to impeach the Deputy President for, among others, violations of a nullified law. The National Assembly then informed the Speaker of the Senate of that resolution, finding that the charge of violating a repealed law had been substantiated. My Lords, Your Leadership, the Senate voted on that impeachment charge on the basis of a repealed section. RG 3745 to 747. Although Article 10 on accountability and the allied case opened all holders of public offices to searching public scrutiny, in ground 9, the National Assembly approved the charge that the Deputy President had grossly misconducted himself by publicly criticizing, my Lord, what offense? Here. What article of the Constitution was the National Assembly stating had been violated by the first petitioner criticizing the NIS director? My Lord, you will see from Article 239 and in fact the NIS Act that the NIS under the Constitution is supposed to be under civilian oversight authority. And the Act itself clearly recognizes that, which is why you will find in the NIS Act, it is 206 of the laws of Kenya. You will find in Part 3, civilian authorities, the heading, effective civilian authority. They then say that the authority oversight. The cabinet secretary is part of the executive. That is not civilian oversight. Simply put, this National Intelligence Act has never complied with the provisions of the Constitution. Had they operationalized that and set up a civilian oversight authority, it is that civilian oversight authority that would take up criticism despite the freedom of thought and expression in our Constitution. The first petitioner was still convicted for criticizing the NIS director. So, my Lord, your leadership, what you are, is that there was absolutely no attempt by the National Assembly, by the Senate, to address their minds to the high standard of gross violation of the Constitution. My Lord, ground five of grossly violating of the Constitution and of failing to uphold his oath of office and allegiance. Instead, ground 5 simply referenced ground 1. This unfair and confusing charge was such that and 3, it still voted to impeach him based on ground 5. There was no attempt to explain even vaguely how the deputy president had violated his oath of office. There are serious reasons to believe under section 13(1)(a) and 62 of the National Cohesion and Integration Act. As I mentioned, my Lord, and I now put this on record, why was he taken first to the National Cohesion, for prosecution before invoking. Because the Deputy President filed a response to the motion before the National Assembly on 8 October 2024 and was granted 2 hours to orally present his rebuttal on the floor of the National Assembly from 5 p.m. to 7 p.m. In the presentation, the petitioner made a cogent response to each of the 11 grounds cited in the impeachment motion. But you see that in Exhibit RG 2, Volume 2, pages 211 to 240. In ground 8, that the Deputy President had acquired property and wealth estimated at 5.2 billion Kenya shillings from proceeds of corruption and money laundering. The Deputy, so where the National Assembly, Honorable Mwengi Mutuse, got 5.2 billion is anybody's guess. If you want to charge somebody, you present evidence that from his brother's will, the bulk of those properties to which the sum of 5.2 billion was erroneously and maliciously attached belonged to his late brother. Gachagua, may his soul rest in eternal peace. Some, like the Olive Garden Hotel, Vipingo Beach Resort, Queensgate Serviced Apartment, he did not even own, was impeached on. But we are falsely attributed to him. He produced ownership documents showing otherwise, and you will find that, my lord, in RG2, volume 2, pages 211 to 214. Lords, although the mover of the motion listed that the 2 companies alleging that they had been used to massively launder money and conceal proceeds of crime, of corruption, and benefit from influence peddling, there was not a scintilla of evidence to support or prove those allegations. No evidence showed any impropriety. And you will find that in RG2, Volume 2, of the National Assembly. Again, a good professional colleague who I respect, did not direct the members to the threshold test standard, rather than a critical step in impeachment proceedings to alter the sovereign will of the people. And you will find that as message of the Senate number 025 of 2024, approval of special motion RG3. Equally, the National Assembly's decision of 8 October 2024 was invalid on the grounds motion was replete with general unsupported allegations, hearsay, and outright lies, and lacked particularization in 145(1) of the Constitution of Kenya and Standing Order 64(1)(a) of the Standing Orders of the National Assembly. 2, members of Parliament debated and voted on the motions on grounds other than those. Impeachment was converted into an investigation of constitutional violations by a public servant. Members of Parliament, let me skip that and go through the next one. The entire impeachment process was designed to avoid and be ring-fenced from scrutiny and accountability, pushed through with uncharacteristic speed with the intention of ramming the process through before it could be audited for constitutional compliance. The National Assembly prosecuted proceedings offended the President. The 2010 Constitution provides a violation of the Constitution. In other words, the President must take time and choose his deputy. What the country, His Excellency Daniel Teacher Moi, and his Vice President George Saitoti, dangling the Vice Presidency, requiring the President to choose his or her deputy before the election so that the people could themselves vote is a very important aspect of our Constitution. The National Assembly trivialized the gross misconduct standard set out by the Constitution and other statutes for holding public servants to account. And the impeachment motion was replete with generalized statements and supported allegations, hearsay, outright lies, lack of particularization, and but the exposition on all that is set out in paragraph 36 of our written submissions, and I will not take the time of this court through it when we retire. Despite this clearing and fatal flaws apparent on the face of the motion, even on a cursory review, soon after the impeachment, respondent issued a communication from the chair, number 46 of 2024, in which at paragraph 16, 18, and 20, he stated that he was satisfied that all the grounds. The first respondent legally incorrect decision to allow the motion to proceed for debate, despite its clear failure to meet the specificity and accuracy requires haste to pass the motion as quickly as possible in order to shield the process and its obvious serious rules from judicial review. it is our submission that that was the real reason. In other words, Article 50, Sub-Article 2B of the Constitution states that every accused person has the right to a fair trial, with sufficient detail to answer, to be informed in advance of the evidence the prosecution intends to rely on, and to have reasonable access to that evidence. Article 50, Sub-Article 2J of the Constitution, by setting out vague allegations, criminal conduct, including the Deputy President had violated, are repealed sections of the penal code, the leadership and integrity, without ever charging it. Overall, the impeachment motion of the first respondent's communication from the chair was thus incapable of invoking the National Assembly's mandate under Article 150 as read with Article 145. In other words, you will see Volume 1 and RG 8, Volume 7, page 969 to 976. So, that is all I wish to say about A. Let me very quickly move to C. Hello? Is there a problem? Issue C is whether the Senate.
I need to remind you about time.
Of Article 145 rushed the process and denied the Deputy President. The Senate recognizes the right to a fair hearing in considering a petition for removal of a person from office, because they say so in their standing order number 81. The right to appear before the committee, the relevant committee. That is in standing order number 81. Whenever the Constitution or any other law require the Senate to consider a person from office, the person shall, and the word used in standing order number 81 is that the person shall be entitled to appear before the relevant committee. That opportunity to appear before the committee, and the importance of the committee, my lord, is that the committee has got less members than all. And therefore the deputies, by bypassing the setting up of that committee and assuming that the 10 days related to the plenary, which they did not, the Deputy President was denied. The President had all He became mute. None of us, all of us are human beings. You know? Illness does not come knocking. One is just taken ill. And he was taken ill after very stressful, strenuous proceedings, situation for the deputy president to be deprived of that position to which he had been elected by over 7 million people. But when that he had been taken here, we are going to execute with military precision owing to the fact that we need to conclude business today. And he said I had indicated that I could not get hold of the king, admitted to ICU. First, the 10 days did not apply to the Senate. That was a misreading of the Constitution in the law. But secondly, we have to choose to see about the Deputy President improvement. But the Speaker said they could only adjourn up to Saturday. His proposal for adjournment by the Senate adjournment even to the following. And all reasons we are given for rejection of an adjournment to the following day, Sunday. Was a serious violation of the rules of natural justice. Is to be exercised objectively, judiciously, and upon reason, not arbitrarily, capriciously, or on whims. Here, falling ill on the second day of a grueling 2-day working day adjournment to Tuesday, 22nd October, to enable him to recover and appear for cross-examination. The Senate defeated that proposal to adjourn until Saturday to see the Deputy President of the National Assembly. The Senate insisted on proceeding in the Deputy President's absence. My Lord, you will see at paragraph 83 of as Attorney General, it is number 3. It is paragraph 3, page 250 in our bundle. Where the Court of Appeals said the appellant's request for had been held incommunicado. He had less than 10 hours in total. And in a prison setting to instruct his lawyer to prepare his defense of the right to an adjournment to enable a party to adequately prepare his or her case in a criminal trial is underpinned by no less an instrument than the Constitution. The authorities cited above relate to exercise of discretion to grant or refuse an adjournment in a civil dispute. Those are relevant in respect of application for adjournment of criminal trials. Nevertheless, because of the constitutional basis of that right, the potential impact on a citizen's liberty, the court is obliged to be more circumspect in rejecting an application for adjournment and to specifically consider whether denied. I had the privilege of arguing this case before the court martial back in 1983, following the attempted coup, and also through the High Court, through the Court of Appeal. The conviction by the court martial was quashed on the basis that Major General Kariuki, the commander of the unit with which the whole process from the word go all the way through was done, but including the rest of it, but I invite the court to read our written submission. I only mention that after hearing the Deputy President on the 8th of March, finishing it that the National Assembly consider this motion, they voted to impeach close to 9 p.m. The normal working hours are daylight hours. How is it that the National Assembly could not even wait for the day the Senate set the date to commence the procedures? Equally, when the Senate, after depriving the Deputy President a fair opportunity to defend himself, impeached on 5 out of the 11 grounds, equally they had to transmit the close to midnight on the same night. In other words, I'm inviting this court to see this breakneck speed. Somehow, the Speaker of the National Assembly had in advance issued a notice convening a sitting of the National Assembly. on a Friday, which is not a normal sitting day. A good friend of mine, senior. And above all, although the resolution of the Senate was being transmitted back to the National Assembly after midnight, between midnight and the following day, His Excellency the President had time during the night to get clearance for the past from the Electoral Commission. These are public institutions. In fact, the Electoral Commission did not even have commissioners to make a decision clearing the choice of the Deputy President. But I mention this to demonstrate the unholy rush utterly thrown about by the National Assembly and the Senate to confuse issues. They were merely saying we have the numbers. There was no attempt to address serious violation of the Constitution. Not a hand over to Rangi.
My lords and my lady, my name is Elisha Ongoya. Number one, I have reflected on a number of unjust trials in human history. Trial of Socrates, one element characterizes these trials. When you read history, there are trials that are carried out with predetermined outcomes. Those who are taken through the trials are taken through the motions for the sake of it. My learned friend, Mr. Wachira Maina, whom I've had the chance to work with, reminds me all the time, lies a moral idea and a moral expectation that there will be with the commands of that constitution. In fact, Mr. Wachira Maina informs me, and I believe him, that in management theory, there is a concept described as malicious compliance. It informs me that there is a legitimacy gap that is wider than the Pacific Ocean between good faith compliance and malicious compliance. I want to persuade you that the motions that the Assembly and the Senate of Kenya, malicious compliance. The danger of allowing malicious compliance to go unredressed is that there is a gap in constitutional processes. The second inspiration that I wish my lords to bear in mind as you determine this matter was set out by the Court of Appeal of Kenya in the case of Martin Nyaga Wambora and 3 others. But this system, I'll be very emphatic of which particular court I'm referring to when I refer to the Wambora case. So I'm looking at the Court of Appeal 2014. In that matter, the Court of Appeal began by setting out what would inspire it as it writes that judgment. So you look at paragraphs 2 and paragraph 3 of the 2014 Wambora case at the Court of Appeal. The Court of Appeal observes, and I quote, "No party institution is immune from judicial scrutiny." I say this because to such other debt as you shall defer us to, some people will take this stand and tell you that there are political issues here that are immune from scrutiny. The second inspiration that the Court of Appeal set out in the Wambora case, not Parliament, Judiciary, which is supreme. It is the Constitution. I stand here to canvass one substantive question, a continuation of the threshold concerns surrounding the motion, particularly as eventually approved by the Senate. In the now, that lowering its bar too low or allowing it to become a facade that masks hidden political interests runs the risk of Kenyans losing confidence in the process. That's the big risk. 2, if we allow what happened in this country, culminating into the resolution of the 17th of October 2024 to stand, it's a threat to confidence in our constitutional democracy itself. Allow me just to reiterate one question that has bothered me and my learned senior colleague, Senior Counsel Paul Mwita, has started. On 17th of October 2024, I'll draw your attention to in a short while, the Speaker of the Senate delivered a communication from the chair, an actual ruling, which informed the members that the first petitioner was in fact indisposed and not available to be heard as guaranteed by law. My lords will agree with me, it requires extremely compelling reasons to insist on proceeding with a case where the subject of that trial is indisposed. It must be exceptionally complex. I have had the misfortune of sitting on the front benches of this case from the time this matter of the National Assembly to the present. This question has disturbed me as a role player in the justice, law and order sector. That the Senate of Kenya, even after the Speaker erroneously, and I use the word erroneously, advisedly, because Malani for impeachment in Article 145 as well that but even if the Speaker erroneously said we have a timeline of Saturday, they had no such timeline, but the Speaker said so. The senators voted to deny the Deputy President the benefit of those 2 or 3 more days without giving any reason. Logic. This court will allow that decision to stand, if no other decision, that particular one. That for no reason. We are not saying the heavens will come down falling. We are not saying the country will be subject to any external attack. We are not saying there is any constitutional imperative that compels us to do it tonight. No reason. Let me go on record. There may have been some veneer of good faith. If they had said it's okay, because we have 2 days, let us give him the 2 days for whatever it is worth. They said even that, we are not going to give it to him. On the threshold questions, the matters that I'm specifically tasked to bring to your lordship's, ladyship's attention are the following. Number 1, Article 150 clause 1 of the Constitution sets out the constitutional textual threshold for removal of a deputy president from office by impeachment. And it says is on the grounds of gross violation of a provision of the Constitution or any other laws. Secondly, it says is on the ground of serious reasons to believe that the deputy president has committed a crime under national or international law. Serious reasons. I'll be making out a simple case that the National Assembly really disappointed the country. To approve a motion that there are serious reasons to believe that the deputy president has violated a provision of the law, section 132 of the Penal Code, which has been declared unconstitutional, null and void, is a locus classicus of lack of seriousness in the reasons. And thirdly, the standard of gross misconduct. Let's face it, my lords, my lady. The drafters of this constitution would as well characterize these wrongs as violation of the constitution, because that's also a wrong, or reason to believe that the DP has committed a crime, or misconduct. Those are wrongs. But they were particular to add these descriptive words, gross, to the violation, gross to the misconduct, and serious to the reasons. The conclusion I draw from this is that they set a very high threshold for removal of a deputy president from office. Our courts have followed cue. I will start with the Supreme Court, sample 2 decisions there, go to the Court of Appeal, sample 1 decision there, then go to the High Court and sample 1 decision there. From the Supreme Court, the decision of Sonko versus the County Assembly of Nairobi City and 11 others. Yes, yes, we do. Yes, we do. Correct, correct. Okay, okay. I'm highlighting, my lord, so I was avoiding reading them. So I'm drawing simply because if I have to take you through the pages, then it means I have to actually take you to the submission themselves. I'm just highlighting salient aspects of those submissions so that we save on time. Thank you. So that in Sonko versus the County Assembly of Nairobi City, I beseech this court to look at paragraph 161 of that judgment. That the grounds for impeachment and removal from the office must be substantiated. The grounds for impeachment and removal from office must be substantiated. It means, my lords and my lady, the motion mover and his supporting cast of witnesses must show us where is the supporting evidence for each of those grounds. They must show where the supporting evidence is. Because substantiation simply means adduction of adequate evidence to lend credence to the ground. The Supreme Court then sets the standard as what has now been called the intermediate standard. Not so low as to be on a balance of probabilities, and not so high as to be beyond reasonable doubt. You will find these descriptive words of grounds for removal from office in removal of other office bearers from office under our constitution, like judges of superior courts. They've removed on similar grounds. And you will see the Supreme Court has dealt with that in the case of Muya versus the tribunal appointed to investigate the conduct of Justice Martin Mati Muya, Judge of the High Court. In that matter, the Supreme Court now attempts to give us the meaning of the word gross. And you'll find that at paragraph 181 of that judgment of the Supreme Court. And it says, and I quote, clearly, all the words used to describe gross express some extreme negative conduct. Not just negative conduct. It says extreme negative conduct. And it proceeds to say a degree of misconduct of such a serious, outrageous, and flagrant nature from office. That is how serious it ought to be. Those are the words of the Supreme Court. So, the Court of Appeal, I have already observed, sets that standard in the Martin Nyaga Wambora and 3 others. I'll just refer of that judgment. But there is something else that I want us to draw from the Martin Nyaga Wambora case. How to frame charges for an impeachment motion. Because the Court of Appeal also dealt with that question. 44 in Court of Appeal decision, that's one I have in mind. If you look at paragraph 44, you will see that the Court of Appeal draws similarities in drawing charges for an impeachment motion to drawing criminal trial charges for court. In trying to explain how specific a charge for impeachment should be. I say this because in drawing criminal trial charges, there is a wrong in framing charges called multiplicity of charges, and I'll show you how that wrong applied in the trial of His Excellency Rigathi Gachagua through 259 of that judgment of the High Court. For ease of reference, I will refer you to the various aspects of the impeachment motion that is in volume number 1 of the petitioner's document from pages 1 to 209. Look at that volume. At 5, you will find the Hansard of 16th October 2024. Then in part 6, you will find a continuation of the Hansard of 16th October 2024 and the Hansard of 17th October 2024. That Hansard in 10 at paragraph 31 of that affidavit, which was sworn on 21st October 2024. So, returning to the question under scrutiny from my end, I would invite you to look at page 59 of the highlight, not paginate the full bundle. So you look at the page of the Hansard itself. Something very interesting happened. I want to paint the picture so that I abridge on time. Before the trial of His Excellency Rigathi Gachagua, the Senate issued a trial schedule, a schedule of the proceedings. The National Assembly had given the Senate a list of 5 witnesses. His Excellency, the Deputy President, the National Assembly presented 5 witnesses. When the schedule came, the schedule gave the GP's team 2 hours to cross-examine the 5 witnesses of the National Assembly and 3 hours to lead the evidence in chief of the Deputy President. The Deputy President's team took the view that it to take their witness in exam in chief. This is their own case. They suggested to the Speaker that we need these 3 hours for our exam in chief, and perhaps the 3 hours for our cross-examination of the National Assembly witnesses, and perhaps the 2 hours for our exam in chief. So we are not taking any more time of the Senate. We are just reordering our own time, the one you have given us. I mentioned three significant trials that have shown me that when these kind of things happen, it means there is malicious compliance. We are simply going through the motions. No one is asking for the Senate any more time. We're just saying of the time you have allocated us, we have a lot more duty in cross-examination. Give us more time towards that. It is judicially noticeable that the Speaker of the Senate is a lawyer of many years standing. It cannot be that he didn't understand the injustice inherent in the disproportionality in that time allocation. It cannot be he didn't understand. He understood it by virtue of the trust bestowed upon him as a trained lawyer. Allow me to then very briefly take you through the various grounds of impeachment as set out in the motion and the evidence, what the evidence revealed in respect of each of those grounds. I would start with the pillars of ground 4 of the impeachment motion. This is one of the grounds that the Senate approved and which contributed to the loss of office of His Excellency Gachagua. The particular state that the Deputy President made a scathing public attack and filed a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. It is a requirement in impeachment proceedings that the impeaching house cannot introduce as approved by the National Assembly. The ground was that the Deputy President made a scathing public attack against the Honorable Lady Justice Esther Maina, Judge of the High Court, and falsely threatened to file a petition against the said judge in gross violation of Article 160, Clause 5 of the Constitution. So a number of things are important, my lords, my lady. It provides that a member of the judiciary is not liable in an action or suit in respect of anything done or omitted to be done in good faith in the lawful performance of a judicial function. It's not liable in suit. You can't take them to court. If you look at ground stating that the threat to take a judge to the Judicial Service Commission is a violation of Article 160, Clause 5. wonder. Their lawyers are here, they will tell us. In fact, some senators are actually here, they will tell us. How does Senate read Article 160 clause 5 as against Article constitutionally gives any person the right to initiate a petition before the Judicial Service Commission for the removal of a judge. So if you state that you are going to pursue an Article 168 clause 2 process, how can that be a violation of Article 160 clause 5? I was struck. So that the National Assembly brought a case to the Senate that a claim by the Deputy President he is going to file a petition against Justice Esther Maina is a violation of Article 160 clause 5. The Senate approved that ground for removal of the Deputy President. Express text of the ground and the particulars at paragraph 34 of the motion is that the Deputy President had falsely threatened to file a petition against Justice Maina. Now, the Supreme Court has told us the ground must be substantiated. So I will now take you how the motion mover substantiated the ground. If Milimani again, as Annex JN10, the following conversation takes place. The motion mover is being cross-examined by yours truly. The Hansard of the Senate captures me as asking this question: do you still stand by that part of your allegation that he has not presented the complaint to the judicial since learned that he did present the petition? The motion mover is conceding that he's claiming the motion that the Deputy President falsely threatened to file the petition cannot pass muster. Yours truly, my lords, then suggests to him that to the extent that you say that he has not presented the allegation is not true. Is it? The motion mover says we are in agreement, counsel. The motion mover concedes that the ground on which his motion is founded, ground 4, cannot be substantiated. With this Hansard before them, members of the Senate voted to approve this ground. Can it that it? The third aspect I want my lords to reflect on when you retire. You can answer this question either way. Some of us enjoy reading these judgments either way. But I want direct answers to these questions. A judge has had a case and delivered a judgment and a verbal criticism of the manner in which that judge conducted herself in that case constitutes a violation of the decisional independence of the judge. That's what the ground said. It said gross violation of Article 161 of the Constitution on the institutional and decisional independence of judges. So by decision she has already rendered and become factor of issue amount to a threat to the decisional independence of that judge. Which decision? She has already rendered the decision. I submit to you, my lords, that it is actually good democratic practice to subject judicial decisions to heightened, and therefore what the Senate did by approving this ground was a clawback on an important democratic practice of enhancing judicial accountability. Two grounds that I want to do simultaneously are grounds 5 and 6, because they suffer the same fate of inadequacy. Grounds 5 and 6. Ground 5, and both of them were approved. So I've already dealt with one that was approved. I'm dealing with two others. Then I'll deal with two others to finish the 5 that were approved. Ground 8, 5A of the Constitution and fidelity to the oath of office and allegiance. Then ground 6 provided that the deputy president, that there were serious reasons to believe that the deputy president had committed a crime under Security and Integration Act. Those were the two grounds. So, a ground must be supported by particulars. That's what the Supreme Court has said. Then the particulars must be substantiated. Now, when you look at the motion, ground 5 had no particulars of its own. Of this motion, in his drafting wisdom did, was to say the grounds in support of ground 5, the particulars in support of ground 5 are the particulars in grounds 1, 2, 3, and 4. That's what he said. Similarly, in respect of ground 6, instead, he said the particulars in support of ground 6 are the grounds set out in the particulars set out in grounds 1, 2, 3, and 4. My lords, as experienced jurists, you know better than I do that particulars are the specific acts or omissions constituting the wrongdoing. The specific act, the sentence said, we are charging the deputy president in ground 5 and ground 6 because of the acts and omissions we have referred to in grounds 1, 2, 3, and 4. Is that a permissible way of framing a charge of impeachment? I began by setting out that it has been established that this court, the High Court rather, has held in 3 different cases. The case of BMK versus Republic, 2020 EKLR, the case of LKO versus Republic, 2022 EKLR, I just refer to one because they make the same principle. Yes, Zongudi said, and I quote, "The problem I find in the charge sheet is one of multiplicity of charges." Then she defines multiplicity. Multiplicity in a charge sheet arises from charging of a single criminal act as multiple separate counts. Paragraph O of the Constitution. That multiplicity of charges is a violation or a threat to Article 50, Clause 2, Paragraph O. And it defines multiplicity to mean charging a single act as multiple separate counts. So therefore, when the National Assembly tells us that are the same acts that constitute the ground 5 and ground 6, these two grounds were bad for multiplicity. They were a violation of Article 50 of the Constitution. They cannot found a threshold for impeachment. Both of the two grounds. The president from office. But there's something very bad about it. The Senate voted to approve grounds 5 and 6 on the particular set out in 1, 2, 3, and 4, and ground 5 on the particular set out in grounds 1, 2, 3, and 4, but acquitted. And that's how obscene this trial in plenary is, as my learned colleague, Mr. Chell Dudley, will take you through in a short while. Then finally, ground 1. Ground 1 accused the Deputy President of gross violation of Articles 10(2)(a), B, and C, 73(1)(a) and 2B, 75(1) and C, and Articles 47(1) as read together with Articles 131, 2C and D of the Constitution. In summary, my lords, these were the grounds that accused the Deputy President of talking about shares in government and shareholding in government. Let me just paraphrase it like that. That's in summary what this is about. The motion mover, through cross-examination on this ground, you will find that at pages 88 to 94 of the Hansard of 16th October 2024. That the government of the day in Kenya is formed by a coalition of parties named the Kenya Kwanza Coalition. Motion confirmed that as a fact. Number 2, he confirmed that the Kenya Kwanza Coalition was formed of Number 3, among the parties were UDA, ANC, Ford Kenya, and PAA or PA, as is sometimes called. And my lord, this leader was the Speaker of the Senate presiding over these proceedings. When you finally take time to read pages 88 to 94, the motion mover confirmed that each of these coalition agreements made references to share. You'll see the coalition agreement between Ford Kenya and ANC talking about certain roads in Western Kenya, nowhere else. You will see the coalition agreement with the PA talking about development of marine resources in coastal Kenya. You see portfolios. The leader of the party called PA being promised a position of the Speaker of the Senate. The question therefore is that when parties enter coalition agreements and pre-election manifestos, it is the people who determine whether they want to be associated with that at an election. For some reason, the people of Kenya chose this agreement with shareholding arrangements in 2022. If the people of Kenya are unhappy, they have another opportunity in 2027 to deal with it. And that is exactly what the High Court set out in the Sonko decision. High Court Sonko decision at paragraph 258. The High Court says an impeachment is an important remedy but one of last resort. It is one to be used where there is an injury to the people. The remedy should be limited to only the gravest political wrongs. This is because the person to be removed came to office through a popular mandate. That the wrong committed by the official proposed to be impeached cannot wait to be corrected through the ordinary electoral cycle. If the people of Kenya had gone to the 2022 elections on the strength of these pre-election arrangements that talked about shareholding, it follows that they had a chance to revisit that question at the next election. At page 95 of the Hansard of 16th October 2024. You'll find the following very interesting conversation between Counsel Tom Macharia and the motion mover, Ecomas Mwenge Mutuse. I'll briefly take through the conversation, my lord, but you will take note of it by playing a video to the motion mover and pose the question, who is speaking in that video? The motion mover, Mwenge Mutuse, responds, the President of the Republic of Kenya, Honorable William Ruto. Tom Macharia then poses the question, which words did he use? What has appointed many of the locals into his government? Tom Macharia prods further, did he say, nyinyi watu wa Murang'a ni shareholders wakubwa wa hii serikali? Mwenge Ruto says, yes, he did. The people of Kenya have not in 2027 following this conversation. The question we want you to deal with is this. Why is the president's reference to the people of Murang'a as shareholders in his government acceptable political rhetoric? And a similar reference to the people of Nandi and Kericho, because those are the areas mentioned in the motion. It's worth noting that when you read the conversations I've told you at pages 88 to 94, you will find that the person who witnessed the pre-election pacts in Kenya Kwanza was Professor Kithure Kindiki, and despite witnessing agreements with the shareholding model in it, approving now to become the deputy president. It is that uneven-handedness that we want this court to ask itself this question. Did the National Assembly find a wrong, then sought to establish who is the wrongdoer to be asked? What wrong can we put on him to punish him? Which is what appears to me to have transpired in this set of circumstances. I have taken you through the 5 grounds that were approved by the Senate to them. They were bad for multiplicity. That's grounds 5 and 6. They fell short of the threshold as set out in Article 150 of the Constitution, as expanded upon through judicial interpretation. And therefore, generally, while principally therefore beseeching this court to allow this petition, allow me now to invite my learned colleague, Mr. Chel Dudley, to take you through the reading of the constitutional prescription on the impeachment procedure and how the interpretation of those provisions by the
Thank you, my Lord, for the opportunity to address you on this important question. When we last left the court, I had thought that we were done with jurisdiction, but the National Assembly petitions saying that you either lack jurisdiction, or if you have it, then you're limited to looking at the process. And you should not hear the substantive violations that my 2 colleagues have told you about. They cite, quite helpfully to us, a Filipino case, Francisco versus House of no jurisdiction to review impeachment proceedings. The court concluded that that process has procedural safeguards, and therefore it answers to a legal process. My Lord, that stance, the stance that the proceedings you're dealing with are both political and legal on the executive. My senior counsel team leader Paul Mwito was a delegate number 114. The current speaker was delegate number 209 at the CKRC conference. And you'll hear Professor Githu Muigai, when he rises, tell you that these provisions on impeachment were hotly contested. They were the law. Every word in a legislation must be given a meaning. Now let me begin with what's common ground. On 9th October 2024, JN4, the affidavit of Jeremiah Nyegeni at paragraph 22, the morning sitting, the Senate for governors and deputy governors. He says we have a motion is the first for impeachment of deputy president, but we have two options that we have when it comes to the impeachment of deputy governors and governors. My Lord, that is a heresy. The Senate does not form the committee, the special committee under Article 145(3) is not formed. Why? The Speaker misleads the House that they have two options. They can either investigate the charges by committee, Article 145(3)(a), or they can investigate by plenary. Let's be given our rejoinder submissions, table 1, because I intend to spend a moment or two there. Look, the Senate picks the 10-day timeline applicable to the special committee. Remember, they've dropped the committee. They've said, no, we have two options. We're investigating it in plenary. But they retain the 10-day timeline applicable to that special committee. False. The Speaker holds on to the 10-day deadline applicable to the special committee for a plenary hearing. And the members of the Senate vote to deny the Deputy President even the benefit of that 10 days, the balance of it. They say we must conclude our business today. In doing that, the Senate, number one, we tabulated the differences between Article 145(3), Senate Standing Order 78 and 80, and Rule 2, Rules of Procedure for removal of the Deputy President by impeachment and governors. My Lord, Article 145(3) does not give two options. It gives one option, which is of the National Assembly resolution. The Senate Speaker shall convene a meeting of the Senate to hear charges against the President. And the Senate, by resolution, may appoint a special committee comprising 11 of its members to investigate the matter. The special committee has a constitutional function. It investigates the charges to the Senate here, but will tell you where that may originate. But as it is, it makes grammatical sense. The Senate must convene within 7 days, and if the Senate convenes in 7 days and the motion is approved, there's something worthy of investigation here. The Senate may. The charge is that the Deputy President, the President, wore a yellow shirt, he should have worn green. Or he wore a blue shirt when he should have worn a red one. Flimsy charges. My Lord, the test on threshold has already been laid to you. So literally, grammatically, Article 145(3)(a has an and. If you go to 143(5)(b and you begin with the Senate began to the and is disjunctive. It means you must bring both elements of the law together. Parliament does not waste words. Every word used by Parliament in a law has meaning, and the court must give each word in the law meaning. Standing Order 78, which is a provision applicable to the President, reflects faithfully the wording in Article 145(3), word for word. Then, this is where the original sin happens. Standing Order 80, and that is on page 2 of our table 1. I really hope that my lords have it so that we... Standing Order 80, which is the procedure applicable to governors and deputy governors. It allows the Senate to investigate in plenary. Standing Order 81 says, within 7 days after receiving the resolution, the Speaker of the Senate shall convene a meeting of the Senate to hear charges against the governor, and comprising 11 of its members to investigate the matter, or investigate the matter in plenary. The Speaker imports this or in Standing Order 80, brings it to Standing Order 78, replaces the and there. The Senate shall convene and may by resolution appoint a committee. You can go investigate this by special committee, or you can investigate it by plenary, like we do for governors. My Lord, if you look at the constitutional article for impeachment of governors, you will not find the kind of detail that you have in Article 145. Why? My learned friend, my senior Professor Guido, will tell you that in the history complete with detail, but the Speaker here replaces the word or in Standing Order 80 and takes it to Standing Order 78 to Article 145(3). He deletes and implants or. What misled the Speaker could be is Rule 2. Rule 2 same mistake. It replaces the legislative word and in Article 145 with the or, disjunctive. My Lord, Rule 2 says the Senate may in plenary investigate the matter and determine whether the particulars of the allegations against it, the special committee is gone. For 145(3) and then descends to B. By plenary. It's saying the Senate may investigate by plenary. Where did this error originate? In the making of our constitution. My Lord, I go to that because if, suppose we are not making sense and our holistic to look at the text, which we have done, and the history. What was the history? And how did we end up with a provision that, quote unquote, could sound difficult? My lord, the theory of holistic interpretation is mainstreamed as a theory of interpreting our constitution. To do that, allow me to draw your attention to a fresh new publication of the Senate. And that is a digest of the law and practice on removal of county governors and deputy county governors from office through impeachment. First edition, brand new, published last year. I apologize, I haven't yet produced it to the court. I intend to. It says committee vis-a-vis plenary proceedings. And the Senate, this is about governance. It says that the law does not provide for any specific procedure. Page 104. A case digest. You do not have it yet. I've just apologized that I came across it yesterday because it's a new publication, but I will put it on record. When you turn to it and you look at page 104, you find that the Senate says that is what informs the rules of procedure. Investigate. And that is also what informs Standing Order 80, where the Senate may use plenary to investigate. But, my lord, the Senate recognizes what this court has in Sonko High Court. This court said that we are of the considered view the President is a more serious undertaking. For this reason, we recommend that it will be desirable in future impeachments to proceed through the committee route as opposed to the plenary. This High Court has recognized the inherent risks in investigating through plenary. Why? We say so. A committee, it has 10 days to deliberate on the matter, thus giving many opportunities to the parties to prepare their cases adequately. The committee gives the perception that each member is actually engaging in the process as opposed to the plenary, which can be perceived to be a mob lynching process. That's exactly what happened here. That trial on removal of governors and deputy governors, a publication of the Senate, brand new 2025 bond. Trial by committee gives the Senate, through the 11 members, an opportunity to review the usually voluminous documents from the governor's team. A trial by committee of
as a request, we clarify the record when my colleague is addressing that point. In his written submissions, that decision is describing, it is described as a decision of the Supreme Court, but it is actually a decision of the High Court. So that we don't have to later belabor this point now that we're addressing it. Can it come up? Because the written record says,
learned friend Mr. Mudomi Tiankula, very good interrupt at this point, indicating its importance. it's an easy one. The decision is High Court, Sonko. There's a typo saying it's Supreme Court. It's High Court, but it's what the court has said. Now here, at page 105, where I was, the Senate is speaking to a member of staff of the Senate involved in this process. That's what this report highlights there. And this member of staff, I hope it's my learned friend Ms. Tanji, is saying that he is able to probe and follow up with specific questions, especially where the grounds for impeachment are technical. Perhaps the committee would have caught out that in Robert Alai, a case I was fortunate to argue with my learned friend Mr. Ongoya, the court had already nullified section 132 of the Penal Code on undermining the authority of a public officer. It says that there are some benefits to the plenary report as well. My Lord, in short, what you are saying is that the motion to impeach the Deputy President was contingent on the special committee's report. It's not just procedural. There's also a substantive right given to him before that committee. Look at Article 145(5) of the Constitution. The Deputy President has a right to be heard. That's a grave violation of the Constitution. My Lord, the final chance that he had to be heard was also denied to him, the adjournment. When something like that happened in a case that my friend, Professor Ojenda, Senior Counsel, argued with his usual merit, Onyango Law versus Kisumu County Assembly, April 3, the Court of Appeal was persuaded that Onyango Law had been denied a fair hearing. And just like in Oloma Law, the Senate here speedily approved the motion, skipped that special committee altogether, but retained the 10-day timeline. I wonder what the 10-day timeline requires reasonableness. It obviously can't delay until the end of the term, but that 10-day timeline was a stranger in the process. And so the Court of Appeal was persuaded that Onyango Law was unfairly impeached. My Lord, we ask you to take the Onyango Law decision and...
Interrupt at this stage. I don't like interrupting things at all.
My Lord, whereas the special committee would have had the deputy president over 10 days, he was investigated in plenary over 24 hours and impeached in his absence. So I ask you again to take the Onyango Law decision, and where it says Onyango Law, please substitute Rigathi Gachagua and make your decision. As Article 145. And my Lord, the theory of holistic interpretation requires you to consider our social, our political, our historical context as a people. That history has names like Oginga Odinga, mistreated by the president and fairly removed from office. It has Kungu Karumba, George Saitoti. At some point, the president served entirely at the president's mercy. That was the framework that the 2010 Constitution sought to transform. Is fundamentally familiar with the drafting history of Article 145. We would not have been here for this. We would not have been taking this process. The president would sack the vice president at whims, including for so far-fetched. It is on the answered record. My Lord, that's a correct reflection on the intention, on the history, on the motivations, on the framing of Article 145. In the National Land Commission versus Attorney General Supreme Court advisory opinion, the court held that unlike the independence constitution that failed to constitution integrates that history and the people's view. And so, my Lord, when you turn to interpret Article 145 and you encounter the challenge with the may appearing in the second part of it, in 135 3b, and you wonder why does it appear this way, you must remember the history. Speaking of history, at page 182 of the CKFC final report, and that, my Lord, is the lawyer's Bible, is the constitutional lawyer's Bible. It is the reference point for ambiguous text. We go back to it to see what was the intention here, what was the struggle, what was the mischief. The people said that, I quote, there should be that the president must be amenable to impeachment. It is a remedy of last resort, but what procedure do we use? My Lord, in the Bomas draft that came out of that conference, the CKFC proceeding, we had Article 164. Article 164 of the Bomas draft. It had a bit more clarity. Why? Because the kind of... Thank you, my Lord. My Lord, because the kind of contestations that attend the making of any constitution had not been there. Remember, by the time we are getting to 145, we've gone through a failed referendum, we've had the Wako draft, we've also had the Naivasha process that messes up and moves articles around. So back in Bomas, Article 164, this is what 164.4 said. If a motion is passed under Clause 3, Clause 3, the Senate, as a special committee, in accordance with the standing orders, to investigate the matter. So this committee was there. 164.4 Bomas draft. Matter 164.5 Bomas draft, and shall within 10 days. The 10 days is also there. It's not a new invention under 145. 164 Bomas draft had it. Also to be heard before the committee was also there. 164 Bomas draft. 63 of the Guy draft. And it also said that if a motion is passed under Clause 2, the Speaker shall constitute a special committee comprising the Chief Justice and 13 members of the National Council. So even when this committee was thought the Chief Justice should sit on it, it was there. When the name changed to National Council, the committee was there. It has consistently been there. Article 163.5 or the guide draft provided that the President and not 146 to 2009 harmonized draft constitution by the Committee of Experts. My Lord, 163(4) of the guide draft also required the committee to investigate. So its function was there, its composition changed a little bit, but the entitlement to appear before this committee and to be heard during the investigation of the charges was consistent. Article 170, 2009 harmonized draft. Now we are getting closer to the referendum. 173, upon hearing the charges and 2009 harmonized draft, upon hearing the charges under clause 2, the charges approved in the motion that has come from the National Assembly, the Senate may, by resolution, appoint a special committee comprising 11 of its members to investigate the matter. So the number is now at 11. And the special committee shall investigate the matter within 10 days and report the particulars of the allegations against the President to have been substantiated. The President, you can guess, shall have the right to appear and be represented before the special committee during its investigations. My Lord, now we go to Naivasha. A constitution is a political charter. You need to get consensus and have the document passed, or you have no constitution at all. And so we take it as it comes, with ambiguity. But that's not the kind of ambiguity that scares this court. The court would be adept to interpret the Constitution together with those ambiguities, understanding its history. Now, ambiguity is coming in. Naivasha, the Parliamentary Select 27(3). And the saying, upon hearing the charges under clause 2, the National Assembly. Now, you know, they are also shifting it from the Senate. They are bringing it to the National Assembly, Naivasha. The National Assembly may, by resolution, appoint a select committee comprising 11 of its members My Lord, from 127.3 Naivasha, it gets back to 145. And that's how it sounds vague. That's why it, throughout that history, the 10-day period is there. I am concluding, my Lord. The function of the committee, when on 9th October 2024, the Speaker, what is the source of that? Two senators. What gives him the right? It's not even the standing orders. My Lord, he fuses, the Speaker fuses Standing Order 78, Standing Order 80, the Rules of Procedure, and Article 145. And in that process, Article 145 suffers violence.
Just clarify, you said that it appears ambiguous.
Yes.
Is it ambiguous?
It is not ambiguous. If you look at its history, if you look at its intention, if you consider that constitution making, Speaker of the Senate versus Attorney clear. The Senate may appoint that committee if it finds that there's something to be investigated. My lord, blue shoes, nothing to investigate. What's the committee to investigate? May turns to must. It must only appoint if malicious and malicious compliance. If there's nothing to be investigated, there's a need to appoint the committee. My lord, let me move forward and say that in Speak of the Senate, the Supreme Court explains precisely this kind of phenomenon, where the document born out of long-drawn negotiations, 2002 when I was a schooler to 2010 when I joined the university, long-drawn process. The document is looked at, touched by many hands before the battle, which can occasionally lead to this kind of contradictions, where you have a shall in 145(3)A and the may in 145(3)B, and to those who are mischievous, it appears to be ambiguous. My lord, political and social demands of compromise that mark constitutional moments fertilize vagueness in Procedural court, and we ask you to interpret Article 145(3), considering the history I've laid out. Constitution making does not end with promulgation, it continues with interpretation. It is the duty of the court to illuminate legal penumbras that constitutions born out of long-drawn compromises such as ours tend to, has to be invoked by the court. If this clause was so contentiously debated and nearly cost us the Constitution, how is it that the drafters could have intended that Senate can investigate these serious charges in plenary without saying so? How can such a serious provision be left to inference by a technical interpretation that's discretionary? What about the and before the may? My lord, how could the drafters have intended that Senate could investigate in plenary within 24 hours, even denying the subject of the impeachment a fair hearing? I turn to an issue of comparative constitutionalism. My lord, no other country that can be done in 24 hours. According to my research, South Africa has the panel at Article 89 of its constitution. We call it special committee. South Africa calls it independent panel. The role of that independent panel, Section 89 South African Constitution, is to determine of a serious constitutional violation of some of these things that we are now confronting you with. Section 132 Penal Code, nullified. How can it form an impeachment charge? United States uses the House Judiciary Committee to investigate the charges. My lord, in 95 of the Nigerian Constitution, there's a panel of 7 members of unquestionable integrity, but who are not politicians or civil servants for independence. Panel of 7 appointed by the Chief Justice. If my learned friend Professor Ogenda were not a senator but were a Nigerian citizen, he would sit in Philippines. It's called the Committee on Justice, this special committee. In South Korea, Article 65, the committee is called the Legislation and Judiciary Committee. It investigates the charges after a motion is proposed, though the Constitutional Court ultimately will adjudicate the trial. Investigating House Committee. My Lord, the long and short of it is that what we had here was not a constitutional process that is worthy of this court's protection. If you faithfully interpret Article 145, Standing Order 80, if you look at the rules of procedure, Rule 2, and then you spend time, my Lord, with the history of Article 145, you will arrive at one inevitable conclusion. That is a conclusion that failing to appoint the said by Article, my Lord, grossly violated the Constitution. And that violation was not harmless. It bogged the Senate down into a fictitious timeline. It said we are not appointing the committee, we have two options. No, they did not. But then they that for the plenary investigations. What do you have? You have a sham of a trial. And in trying to punish the man regarding Gachagua in that way, the Senate and the National Assembly demeaned his office. They demeaned the office while trying to punish the man. They, my Lord, Constitution.
I think we have made good progress. We adjourn for lunch, then we come back.